And this matter comes before the court today on Miss Davis's application for a reduction of the bond that it's currently appears to be holding her in the Kent County Jail. At this time, I'd invite counsel to place your appearances on the record.
Blair Lockman for the people, Your Honor.
Thank
Jeff
you.
Kirkhoff on behalf of Ms. Davis.
Very good. Thank you, Mr. Kirkhoff. And Mr. Kirkhoff, it looks to me like a bond on this matter is currently set at $50,000 cash or surety, with the requirement that Ms. Davis only be released if she is released on Tether. Um, and you are requesting a personal recognizance bond because she has no ability to pay it looks like either a cash surety bond or the Tether amount. Is that correct?
That is correct. And
Oh,
previously she was homeless, and now she has a place where she can live with her son.
okay. All right. And would that be the same location she was living at prior?
No, she was homeless at the time this incident happened.
I see. Okay. All right. Because well, at least one of the reports I have here says subject used a knife to stab a random person in the face. The two are neighbors in the same apartment complex.
My client's husband lives in that apartment complex, and she was over at his place, and she occasionally stays there with her husband. But she does have a separate, different release address now.
Okay, I see. Okay, thank you for that clarification. Uh, Mr. Lockman, what's your office's stance?
Your Honor, we strongly oppose this request. This was a random and serious act of violence. Victim almost lost her nose in this. That's why she's present to request this court to, I mean, she knows she can't speak at the bond motion, but she's requesting this court to deny this motion. Just looking at her criminal history, she has 9 prior assaultive crimes. Tether's not going to keep this victim or any other victim safe. And I think bond of 50,000 cash surety is not unreasonable. She's got a 25-year mandatory minimum she's facing if convicted of this charge. According to the information, this is Miss Bartlett's case, but I'm standing in for her today. This court would put a lot of people at risk. I'd also note there is a report, and I'm not familiar with this case. It's just a note from June of 2025, and it appears that the defendant called the victim's boyfriend requesting the opportunity to pay for her not to show up to court. So there are a lot of reasons this bond should be denied.
Okay, all right. Well, given I have to agree with the prosecutor's office on this one, that the cash or surety bond certainly is warranted. Something that I am aware of, and obviously is probably impacting Miss Davis here, is that if I had a $50,000 cash or surety bond, I could post it. As everyone at this hearing might be able to do. However, for some people, it's simply financially impossible for them to post that. And if the person's really such a danger to the community, and it looks like that could be the case, well, then, the cases in the court will say, Judge, you should just remand without bond. And I think it's a legitimate concern. However, I do think in this case, the interest of public safety is being served by her continuing in custody. The current bond level is doing that. I'm going to keep bond as currently set.
Thank you, Your Honor. Hey,
Thank you.
Yeah,
Blair, could you send me whatever is supposed to be this contact? I
yeah.
assume if she
It's
was,
just a note. I don't have the actual
oh,
contact in here. I just have a note, but I'll request that someone actually look into it.
thank you.
Yep.
All right. And Mr. Lockett appears today on a request for an early discharge from probation in this matter. It appears that I placed you, Mr. Lockett, on probation. Well, looks like on or about about a year ago, July 3rd of 2024. and it looks like I gave you a period on probation of 2 years, and we're at the 1 year point, and you're requesting to be discharged. I don't see the probation agent here. Is that still Miss Salinas, Mr. Lockett? Mr. Lockett, you may have frozen up on me. I can't hear you, and your video appears to be still right now. If you need to, Mr. Lockett, you can discontinue the video portion and just proceed with audio. Now that I've seen you and that I'm genuinely talking to you here. And Lisa, we may need to kick him out and then readmit him if worse comes to worse. Mr. Lockett, did you have an opportunity to request to talk to your probation agent about the request for early discharge?
Yes, me and Miss Salinas communicated. We talked. She said that it was requested in my probation that I was eligible for a discharge after a year of a consecutive payments and things like that. So she gave me the okay and told me what to do in order to set this up.
Okay, all right. So in other words, and we did reach out to Miss Salinas. Normally, the probation officer appears at the hearing and verifies everything you're saying. But Miss Salinas is not here today. Do you know if she was planning on attending the hearing?
She told me that for some reason she, I guess, usually doesn't appear to these type of things. So I didn't understand if that was if she was supposed to be there or not. But I did send her a copy of all of the information that I did, like when I made the motion. So she has a record of that and all of that thing. So
All right, and Mr. Lockman, is your office?
Your Honor, the problem is we don't know two parts. We don't know. I mean, we would want verification from Miss Salinas, plus she prepares the order of discharge. So my feeling is if the court wants to grant it conditionally upon confirmation with Miss Salinas and her preparing the order, I have no problem with that. And then if information turns out to be different, I've never heard of a probation agent being too busy to be here. I'm not disputing what Mr. Lockett said. I mean, this is what they typically do. They typically show up. So, especially if it's on Zoom, it's pretty easy. So I would only request that maybe the court follow up with Miss Salinas, confirm the information and if he's eligible and if he's been successful, and if that's the case, then the court can just sign an order without the need to
have another
come back,
hearing.
have another hearing.
I would be in agreement, and you've been paying restitution. It looks like Mr. Lockett by wage, salary, automatic withdrawal from your pay.
yes, I have it coming out of my check every single week. So yeah.
Okay, all right, and that's been ongoing, and the victim here, I think, was a bank or credit union.
It was AutoZone.
AutoZone. Okay,
Yes.
all right. Now it's all coming back to me how we did this. So, okay, all right. And well, another thing Miss Salinas would assure me that is that we'd have contacted the AutoZone rep and that they knew that and usually when you're paying restitution and doing what you're supposed to do, that can continue. You don't have to be on probation to do that, and they usually won't oppose. But of course, I don't want to speak for them. So what I will do is I will grant an early discharge today, conditioned upon Miss Salinas okaying that and sending me an order. If she does so, I'll reach out to her and let her know we conducted the hearing today and that an early discharge is approved by me if she approves it. If she doesn't approve it, you'll have to continue on probation.
Okay, sounds fair to me.
Very good. Good job on doing what you need to do and taking care of business here and starting some payments on that restitution in a financial case like this. It says a lot to the victim. It says, hey, you're committed to doing the right thing, and that's what I'm obligated to do as the court as well.
Well, thank you for your time, and I appreciate you.
My pleasure. And good job taking care of business on probation, Mr. Lockett. And this matter comes before the court as well on a motion to set bond in this instance. Counsel, will you place your appearances on the record?
Blair Lockman for the people.
And Jeff Kirkhoff on behalf of Mr. Chanel.
Very good. Thank you. gentlemen, and I currently, this is your motion, Mr. Kirkhoff, and it appears that initially Mr. Chanel posted a $50,000 cash or surety bond, and then was arrested on new charges on May 21st to 25, where I revoked bond. Is that where we currently stand?
That is where we currently stand, Your Honor.
All right, and Mr. Luckman, what's your office's position on a reinstatement of bond in this matter?
Well, I think once the court revokes, I don't think they can restate the original. They have to set a new bond. Um, I mean, I recognize this is a paper case, but it's a Class B 20-year felony with potentially consecutive sub 4. This is Ms. Burke's case. It's not mine. She just indicated to oppose a reinstatement in bond. If the court is going to set a bond, we just ask it to be a high cash surety. Yeah.
And I do note that it's a, criminal enterprise case. Do we have any sense of what a, potential amount of restitution might be at this stage?
$58,063.95.
Yeah, that's probably where that 50,000 original bond came from. Okay, all right, Mr. Kirkhoff, anything you would like to add from your perspective?
Only that my client still has his place. He probably, well, he knows he can get a job as soon as he is released. And we are requesting that the bond either be reinstated or at least that, if not reinstated. Thank you.
Okay, all right, and this your client doesn't appear, at least from my review here, he appears to court. In other words, there's not a history of failure to appear. Is that correct?
That is correct. In fact, I guess all the other conditions of bond that were placed on him, he adhered to, and I think there was something from court services indicating that he adhered to all conditions of bond, with the exception of getting arrested again.
And now another concern I had, Mr. Kirkhoff, is in reviewing this, it appears that he had some warrants or charges in different jurisdictions. What's any update on what's going on with those? I always get a little bit concerned that I'd cut him loose on bond and he'd immediately get snarfed up by.
The only one I'm aware of is there was a warrant in Wisconsin, but they chose not to hold him when he posted bond back in January. And they did not choose to try to extradite him or anything like that.
Got it. So he, as far as you're aware, he has posted bond in that case, and he just needs to comply with his court requirements there.
Yeah, I'm not sure if he posted bond. I don't think he's ever been arraigned in Wisconsin on that outstanding warrant. It's my understanding.
Well, I will note that Mr. Chinall did write me, a couple of voluminous letters from the jail advocating for his release on bond here. Part of the reason being so he can assist you, Mr. Kirkhoff, in preparing the defense on this matter, where he is concerned apparently about his co-conspirators rolling on him, as it might be. So it would be understandable in an enterprise case that that would be a concern. All right. Well, I do think a bond is appropriate in the matter. Did he pick up the new charge? Was that the new charge was the CCE charge?
No, it was organized retail fraud.
Okay.
And we just had the prelim in there, but it has not been bound over yet. We're waiting on a decision from Judge Sturkenberg. And then he had a couple of retail frauds out of Norton Shores.
Okay. Well, not
So-
too encouraging.
So just for verification, I was going to say, just for verification, there's multiple offenses while out on bond.
That's correct.
So I do think that right, a bond is appropriate. However, I do think since the $50,000, well, here's what I'll do is I'll set it $60,000 cash or surety, given the amount of restitution that appears to be due and owing and perhaps growing in this matter, and also add the condition that if he does post bond, I would like him to be placed on tether to his residential address with, you know, the ability to leave that address only for court appearances, work, or medical appointments.
Okay, court appearances, medical appointments,
And it, yeah,
or work, correct?
correct. And no contact with any victim, obviously, in any of the cases would be a.
Your Honor, can you add a condition that he also has no contact with his co-defendants? The organized retail fraud was done in conjunction with one of the co-defendants in this case.
That certainly seems reasonable to me. No contact with any co-defendant.
Right? Okay, we do this by video. Blair, do you have that normal,
I submitted a
Right.
normal order. I submitted the standard orders. Those conditions would just have to be added to that order. I think Lisa has it.
all right. So, okay, so then I don't have to draft it. Is that, I just want to
Right.
make sure I know.
Yeah,
where
yeah,
we're-
yeah. Lisa has it. She could just, Lisa, are you able to add those terms to it?
Okay.
Thank you,
All right.
Lisa.
Situation's normal here, Jeff. Lisa and Wendy do all the work.
Yeah, I know. They run the court. You're just at their.
We're lucky Jeff we're lucky Jeff knows how to turn his computer on.
Well, I do know how to do
He's
that.
very competent.
Jeff
Okay.
only got a cell phone like a year ago, so let's
And I don't like using it. All right,
no, you
thank
don't.
you, Your Honor.
Nice to
See you,
you.
Blair.
see you, Jeff.
Bye, Lisa.